morning. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We're being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. If you intend to refer to a child or a victim during your argument, we ask that you please use the child's name instead of their initials instead of their name, because we do post the arguments online. We have read your briefs and we're ready to proceed when you are.
Good afternoon, Your Honors. My name is Dana Gardner, and I represent Mother Sarah Nichols, the appellant in this case, and I reserve 5 minutes for rebuttal. Thank you. A brief history of this case. The child, EW, was alleged to be a neglected and dependent child pursuant to 2151.04C on November 19, 2014. At the dispositional hearing on February 10th, after not only the child but also both parents were appointed a guardian ad litem, the court placed the child into the temporary custody of Medina County Job and Family Services and adopted a case plan with 4 separate objectives. Those case plan requirements were money management program, parenting classes, stable housing and employment, and case management. The court set that for a review hearing on May 12th, 2015, and at that review hearing there was testimony heard, a guardian ad litem's report was admitted, and the court continued the case plan with no modifications. At this hearing, there was no mention of any kind of parenting evaluation that Mother had been requested or referred by Medina County Job and Family Services to complete, outside of that it was a recommendation within the guardian ad litem report. On August 18th, 2015, there was another review hearing set, and at this, the agency included an exhibit that was the result of the report, or that was the report that was the result of the behavioral parenting evaluation. The court also introduced into evidence at this hearing a amended case plan and requested at the end of the hearing, after testimony was taken and after the court had, or the mother's attorney had an ability to cross-examine the caseworker about the plan, orally requested that the court adopt that as a modified case plan of the court. This was after the case plan was admitted into evidence and after the court had the ability to hear any objections on entering that case plan, and then the court immediately adopted that as an order. There was no written motion. There was no prior notice that this was going to be requested, and it was immediately adopted by the judge. This new case plan included 2 separate requirements, which were an intensive parenting class and a requirement that Mother complete counseling and psychiatric services based on this report that was submitted from Northeast Ohio Behavioral Health Care. The caseworker testified that Mother would be able to do 2 separate of these parenting classes that would complete the intensive parenting requirement, and even the court said that this would be something that the court would take a stricter look at had the caseworker not mentioned that these services were already going to be put in place. This was 9 months into the actual case. On October 19th, about 2 months later, the agency filed a motion to modify disposition to temporary custody to sole legal custody of the paternal grandparents of the child. And counsel for Mother requested orally at the hearing an extension of time, 6 months, to continue on the case plan. This was based on the fact that mother had substantially completed the requirements of the case plan, and it would be reasonable to assume that she could regain custody within that 6 months. The court denied that motion and granted the motion of the agency and awarded legal custody to the paternal grandparents. 2151.412F2 sets forth the procedures for amending a case plan. This court has actually held previously the absent written notice that the court and the parties of proposed changes, any proposal will lack such force of court order, and it deprives parents of the due process right to notice. Without giving Mother's Counsel the notice that they were going to be requesting these changes in the case plan, Mother did not have the opportunity to prepare and to cross-examine the witness based on those sought changes. This is especially critical in this case where Mother also had a guardian ad litem of her own. The code provides for this mandatory 7-day waiting period after written notice to allow the parties to object to any changes. And with the court immediately adopting the changes as an order at that hearing, and with this being done by the judge rather than a magistrate, there is no other ability of Mother to object to these changes. There's nothing on the record that indicates that Mother had reviewed these changes or that she had discussed them with her counsel or with her guardian ad litem. There's nothing on the record that suggests that she consented to these changes other than her attorney's failure to object at that point. I know this is a contention of the GAL and of the agency that Mother's Counsel had the opportunity to be heard. However, he only failed to object to the case plan being admitted into evidence, not as it being adopted as an order at that moment. There was another case going on with another child. There would have been other purposes for this case plan to be admitted into evidence besides asking that the court adopt it as an order. And Mother did not have the proper amount of time to review not only the requirements in the case plan, but also to discuss with her counsel and with her GAL to help her really understand how this would affect her rights going forward in the case. At the legal custody hearing, the guardian ad litem and the agency put a lot of emphasis on this parenting evaluation, and the court relied on it several times within its decision. The requirements that were set out through this of the intensive parenting program seemed to be a moving target for Mother. She completed not one, not two, but 5 actual parenting programs that the court still determined did not consider to be substantial compliance. She had obtained stable housing at that point. She had an income. She had several short-term jobs, which the agency stated that this was not significant enough to be considered stable income to support a child. However, she was pending a disability claim at the time. She had various community assistance services that would help provide for her shelter and to help provide for the child. And she was on her way to being able to provide for the child full time. She had not completed a management program due to the fact that she did not have employment and the program would not allow her to complete fully. So she went to another agency and started another money management program. So this is 2 money management programs, 5 parenting classes, a apartment, an ability to provide for the child within the means that she was able to, and being compliant with case management by and large. And the court found that this was still not substantial compliance. The reason for this was that they did not feel that mother had made enough strides in her counseling, which was a requirement of the amended case plan. The court relying on this issue and the admitted evaluation from the parenting evaluation skewed the entire ability of the court to evaluate if it was in the child's best interest for her to be returned home and for the extension to be granted.
You have just over 4 months.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Jennifer Moore. I represent the Social Service Division of Medina County Job and Family Services. The GAL and I are actually going to split the time in half evenly, as he also wishes to be heard.
I'll let you know in 7.5 minutes.
Thank you. As I said, my name is Jennifer Moore. I represent Social Services Division. As Ms. Gardner stated, this case started in November of 2014 when the agency filed a complaint. Shortly thereafter, EW was adjudicated a dependent child, and as this court has held on multiple occasions, when a motion for legal custody is filed where a child has been adjudicated abused, neglected, or dependent, the trial court must look at the best interest of the child in determining whether or not that motion for legal custody should be filed. In this case, I think the evidence clearly showed that the trial court's decision should not be reversed, that there was no abuse of discretion on the trial court's part with regards to the standards of both 2151, 414D1, as well as 310904, which is what the trial court is required to look at in determining what is in the best interest of the child with regards to the legal custody motion. I would state that the record is replete with grandmother's testimony regarding that family's relationship with the child. EW at the time of the conclusion of this hearing, which was April of 2016, she had been in their home for 17 months at that point. She was well bonded to the people in that home, which included paternal grandmother, paternal grandfather, as well as siblings in that home, or I apologize, aunt and uncles in that home. During this time, mother's visits actually had to be suspended, which goes to the stable housing objective that Ms. Gardner referenced in her argument. Mother's housing was not stable at the time this hearing was held in either February or April. There had been bed bugs in the home beginning in January, and due to that and the fact that the problem had persisted, had not been fixed, and continued, visits had to be suspended because of the center and where the visits take place for the safety of the child. So mother had actually at that time minimal contact with the child. She was allowed to talk to the child by phone, but did not exercise that right, as the record shows. With regards to the income, mother did testify at both the February portion of the hearing as well as the April portion of the hearing that she was not employed at either of those hearing dates. In the February hearing, she testified that she had been looking for work for the previous 3 or 4 weeks, and that in the April hearing, she was supposed to be starting a job in 3 days. I think this goes to the trial court's finding that substantial compliance, even with those original case plan provisions, had not been held and shown by clear and convincing evidence. With regard to the parenting evaluation, there is a case that occurred after this. During the pendency of this case, mother gave birth to another child, and there was a case plan created in that case. For the case plan created in that case, the parenting evaluation was ordered, and based off of that parenting evaluation, which was requested by the GAL, the agency had concerns and moved to amend the case plan in EW's case, which it did at the review hearing. The worker at that hearing testified that she had had conversations with mother regarding the results and the requirements that the agency would be asking of mother. So mother did have prior knowledge to the case plan objectives. Because mother failed to raise this error or raise an objection to the case plan being amended at the August 2015 hearing, the standard for overturning the trial court's decision would be plain error. And at this point, mother has failed to show that the best interest would be changed by this case plan not being amended, that the trial court would have ruled differently had this amendment not been adopted.
It seems to me like she's arguing that she didn't have a chance, mom didn't have a chance to object to the amendment.
She was aware of it beforehand, and it was actually, it was brought up, the social worker testified first at that review hearing, and it was admitted as an exhibit. The two new objectives were gone over through the testimony, and then both Mother's Counsel as well as Mother's Guardian ad litem had a chance to question the social worker regarding the new objectives, and she was questioned regarding those new objectives, and like I said, Mother was made aware of those prior to the hearing, because when we get the results, they were reviewed with Mother, and the social worker testified to that.
And that's all obviously in the record.
It is. The social worker testified in the record that she had that conversation with Mother.
And there was no objection?
There was no objection, no, Your Honor. In fact, there was no objection at any point after the amendment was adopted. The amendment was adopted in August of 2015. In October, as this court is well aware, the agency has to file its sunset motion 1 month prior to sunset, which is what the October motion was for legal custody to paternal grandparents. After that time, the hearing was not set until February of 2016. It did not complete that day, and the next available date was in April of 2016. So during that entire time, there was no objection raised to the adoption of this case plan amendment. That being said, going back to the plain error argument, there was no miscarriage of justice. Mother was aware of these objectives. Mother was purportedly working on these objectives. By her own testimony, she went to counseling. She admitted she needed the counseling. She stated that she thought the counseling was helping her. She stated she knew even before we requested it, she needed counseling, and she testified to all of that at the April hearing. Going back to the best interest standards, I believe that the trial court's decision should be upheld by this court based again on the child's relationships with the family that she was living with for 17 months. The time spent in custody, which again was 17 months this case lasted prior to the grant of legal custody. Her need for permanency. It came out in testimony that prior to Mother obtaining the housing in October of 2015, she lived in 6 different places prior to that. And then once she obtained the housing in October of 2015, she had multiple people living with her. And it was conversations that were had with her regarding the people that she had living with her, which were concerning to both the agency and the GAL, which they both testified to at the hearing. So the stability for EW was required, and the agency showed that paternal grandparents could provide that stability that Mother couldn't.
And with that, you have 7 minutes and 22 seconds.
Thank you.
May it please the court, I'm Attorney Mike Daly, Guardian ad litem for EW. And I'm here today. I'm honored. I'm privileged to have been the GAL for EW. She was a very delightful little girl with a lovely smile on her face, and wanted to share one story that I wrote about in one of my GAL reports that I believe you guys had, about her, that kind of, pointed out to me why the granting of the motion for legal custody was in her best interest. I remember one home visit I did towards the end of the case at the grandparents' home, and she was just so free, relaxed, and happy. And I remember her dog Chloe was sitting in front of me, and she went to the dog bowl and grabbed one little piece of food, brought it to the dog, and the dog took it from her hand, and she took that slobbered hand and gave me a high five. We did that several times. She never did anything like that when she was with mom. She was happy, she was well bonded, she was attached to grandparents. She still is. And as you've already heard, mother lived in over 6 different locations. Mother didn't obtain employment. At one point in time, she suspended her own visitation so she could join a carnival with one of her boyfriends. As I testified at the trial, I tried on multiple occasions to address issues I had with the paramour she had. And she kept coming back to, it's my happiness. Not what's in the best interest of this child. It's about me, my happiness. And if my paramour takes precedent over my child, then so be it. And that's why, we're really here today. She chose, not to address the bed bugs. She chose not to address the issues with paramours. She chose not to, seek employment. And with all of the counseling and everything that we saw, there was never a change. The initial issue that brought JFS into this matter was the fact that she couldn't maintain stable housing. Paternal grandmother testified that mother dropped EW off at about a week old and gave her a bottle of Kool-Aid. These are the type of issues that they were dealing with, and that mother never addressed. No matter how many counseling sessions mom went to, there were still the same issues. And we tried over and over, the caseworker, myself, you never want to make a recommendation that a child be removed from a parent or legal custody be granted to someone other than a parent. But it became very apparent to me over the 17 months of this case, the only people who could provide stability to this child were paternal grandparents and not mom. And as the Attorney Moore stated, I think what bothered me even more was from January of 2016 to the final hearing date, mother had no contact with this child. She testified that she could call her, and she never did. And we asked her why, and she said she was too busy. I don't know. I'm not a parent myself, but I just don't know how you can go 4 months and be too busy to even pick up the phone to call your child. And based on all that, I didn't see the commitment. I don't, as you can tell, I mean, like I said, the counseling sessions and everything, it just wasn't working. You weren't seeing results. And at a certain point, this child deserves to be happy, to be in a safe and stable environment, and that is what grandparents gave her. Thank you.
Regarding 4 minutes and 12 seconds.
The GAL said that he based part of his recommendation on the fact that the child had not had contact with mom from January until the end of the legal custody motion hearing because of these bed bugs. And Attorney Moore just stated that these bed bugs had to cause her visits to be suspended. I would like to point out that this was done unilaterally by the agency. This was not something that was done through the court. Again, there was no motion to modify the case plan, which provided for at least 1 hour a week minimum visits between the child and mother.
What about telephone calls?
Telephone calls, the child was under, I believe, 3 years old at the time. I know mother had attempted to make some phone calls earlier in the case, and that she did not feel that bond with the child, like what would be expected out of a under 3-year-old. I know the GAL also mentioned the suspended visits due to mom joining a carnival. That was actually an employment opportunity for mom. She was working at this carnival and was attempting to provide for her child. To remedy that bedbug issue, as JFS has suggested, would have required mother to leave a home with a $0 a month rent and to seek other housing elsewhere. Her case plan required that she have independent housing so that she not be living with anyone other than the child's father, who they were no longer together at
So
the
these
time.
visits were occurring at her apartment.
No, visits were occurring supervised at the agency, but the agency suspended the visits due to these bed
Was
bugs.
she bringing bed bugs to the agency with her when she was having visits with the child?
There's no evidence of that. She alerted the agency that bed bugs were found and asked for assistance, and they suspended the visits.
Did they provide assistance to get rid of the bed bugs in her apartment?
They provided her with some bed covers. During the time that the bed bugs were in the home, the caseworker actually testified that she had not been making home visits due to these bed bugs. So she was supposed to be going out once a month and was not there. Eventually, later on in the case, between the first hearing and the last hearing on the legal custody motion, there were, the agency did pay for Orkin to come out, I believe twice, but mother testified at that April hearing that she had actually gone to the landlord, she had contacted the health department, she had made efforts. Those efforts were just not able to remedy the situation. Likewise, the agency did not provide her with any kind of alternate arrangements to have supervised visits, even outdoors or anything like that. It was stated, I don't remember which one of the employees stated this, but that the parenting evaluation was ordered in her other case. There's nothing in the record to suggest that there was a court order in that case to require her to get the parenting evaluation. There's nothing included in this case on the record to state that that was ordered there. If it was ordered in that case, there's no evidence of that. They've also stated that there's no plain error because there's no, she had not completed the original 4 requirements. However, the additional requirements that were placed on her due to this new case plan and due to moving the targets and suspending the visitation, everything else, that was a detriment to her gaining employment and to her completing the original 4 requirements in being able to provide for her daughter. Thank you.
Thank you. We will take the matter under advisement and issue a decision which will be held to both sides as well as posted to our website and that of the Supreme Court. Thank you for your presentation.
Thank you.